Good afternoon and welcome everyone. Thank you for joining us today for a brief legislative and industry update. With us today are James Coakley, NYSSA Chairman and President at Treasure Island Management, John Dario, immediate past President of NYSSA and Chief Operating Officer at Edison Properties, and Peter Ferraro, NYSSA CEO and founder of Gold Key Properties. My name is Eric Airy. I'm Executive Director of the New York Self-Storage Association. I will be monitoring the questions submitted by today's attendees. Just a few housekeeping items before we begin. All participants have been muted upon entry. The attendee control bar can be found at the bottom of your screen. Here you can adjust your audio settings and connect through your computer's audio, a headset, or connected speakers. This is also where you will participate in the Q&A by sending in your questions throughout the presentation. We will keep identities anonymous. In the upper right-hand corner of your screen, you can adjust your video settings to view this webinar in full screen mode or adjust your view to see the speaker versus all panelists at once. We will follow with a Q&A session as time permits. I now hand it over to John Dario to present the legislative update. John?
Thank you very much, Eric, and welcome everybody to our webinar this afternoon. I'm going to review some of the legislation that is in front of the New York State Assembly and Senate and talk a little bit about our actions as an association with regard to the legislative activity. And then I'll turn it over to James to talk about some of the bigger picture stuff. Fortunately, we have a tremendous lobbyist working for us. Chris Bombardier from Mercury Government Affairs is fighting on our behalf day in and day out. He's got outstanding relationships in both the Senate and the Assembly, as well as in the executive offices. You know, we're really fortunate to get constant work from him and constant updates from him. So what I'm about to run through with you is the latest information as of really this morning, based on Chris's intelligence with what's going on in Albany. I'll start off by talking about some very specific bills that are out there. I'll start with what is called the COVID-19 Emergency Protect Our Small Business Act of 2021. This is a bill that has up to 9 sponsors in the Senate and 83 sponsors in the Assembly. It's a powerful bill that has already passed the Assembly and is awaiting sure passage in the Senate. It's virtually guaranteed to become law. This bill is intended to protect small businesses from eviction due to non-payment of rent. And it has a special provision to create hardship declarations for tenants that are experiencing financial hardship as a result of the pandemic. And those hardship declarations are meant to be submitted by such tenants to their landlords. This bill, based on our assessment and the great advice we received from the association's attorneys, does not appear to apply to self-storage. We have some very specific reasons why we believe that, including some of the specific definitions contained within the bill that don't seem to apply to self-storage, as well as the preamble to the bill, which specifically mentions the purpose of keeping small businesses in their place of business, and the fact that sponsors of this bill have sponsored other legislation that is self-storage specific, which I'll get to in a few minutes. You know, that seems to indicate that the inclusion of self-storage in this bill is not intended, since they are pursuing other bills aimed at the self-storage industry. So while we're fairly confident that this bill could not be applied to self-storage, there is still some ambiguous language in this bill. There are still a couple of places in the bill where language could be interpreted as applying to our industry. We don't believe that the preponderance of the evidence and the preponderance of the language would hold up. But we urge extreme caution in doing any sort of lien enforcement on small businesses. We encourage you, as always, to get independent legal opinion with regard to the impact of this particular bill, assuming it passes, which we believe it will very shortly. Second bill I want to talk about is actually the New York State budget bill. The executive branch put forward its budget recommendations in the form of a set of legislative acts that are meant to drive certain behaviors. One particular article within the budget bill, it's Article 7, is aimed at emergency eviction and foreclosure prevention. This is really also aimed at commercial tenants, and it has very similar terms as the bill that I just described. In fact, there's a lot of crossover and a lot of similarities, and it's entirely possible that if the first bill that I talked about passes, that this particular piece of the budget legislation would fall out, because there's so much similarity. We're not overly concerned about this. We don't believe that this applies to self-storage either, though the reality is that this is actually a bit more ambiguous than the Small Business Act bill that I spoke about a minute ago. This one might have be a bit more of a threat to us as self-storage operators. Though again, with the first bill almost sure to pass, this is likely not a concern. The third bill I'm going to talk about is called the Pandemic Self-Storage Act. And obviously with self-storage in the name, we know that it's targeted at the self-storage industry. This bill is sponsored in both the Senate and the Assembly by some high-powered lawmakers. The sponsor in the Senate is Senator Hoylman, who definitely carries considerable influence. And on the Assembly side, it's Assembly Member Dinowitz, who is a chairman of one of the committees and also carries significant influence. This bill is pretty straightforward. The language is really short and quick. It prohibits self-storage lien enforcement action for the time period from the beginning of the state of emergency, which would be impossible to enforce because that period is already passed. But it extends until the end of the state of emergency plus 1 year, which is obviously an extraordinary amount of time. We have lobbied hard against this bill, and we just yesterday found out that the language was changed. The Senate sponsor made an amendment as a result of our lobbying efforts, and the end date got rolled back from the end of the state of emergency plus a year to May 1st of 2021. That date is consistent with the dates that are in many of the other bills, the tenant protection bills that are out there. And obviously that's a huge step forward, and would be a significant win from the standpoint of changing the end date. However, we still are lobbying hard to add an extra provision into this bill. We are looking to at least, if we can't stop the legislation completely, which we believe while we're lobbying for that as the ultimate answer, we think it's unlikely that we'll be able to prevent something from getting passed. So if something's going to get through, we would like it to include the same type of hardship declaration that exists in the residential and commercial tenant protection bills. And we believe that we will get that. We have received some positive indications from the Senate sponsor that they'll be open to that, and in fact, Senator Hoylman is a sponsor on the Small Business Act of 2021 that includes the hardship declaration. So we believe that just by mimicking the same language he's got in his other bill, we'll be able to get that into this bill. And we have every reason to believe that we'll be able to achieve the same thing on the Assembly side. So while any sort of prohibition on lien sales is certainly not what we're going for here, it's not something we support and favor. Being able to scale this back to a point where the ending time is reasonably within a couple of months, and more importantly, the hardship declaration exists. We believe that it's at least a significantly better result than what we will otherwise end up with. I will say that the indications from at least from the senator's office are that the pandemic pledge, which we have put out there and many of you have signed on to, and you can find on NYSSA's homepage on its website, that pandemic pledge was instrumental in allowing us some leverage to get some language changes here, and the fact that we as an industry were willing to make some voluntary statements on how we were treating customers who are financially impacted by the pandemic. The lawmakers did take notice of that and have been willing to work with us because they recognize that we're trying to do the right thing here. There's a couple of other, I guess three other bills that I want to touch on. None of these are they're all bad bills, very bad bills actually, but none of them seem to be in imminent danger of being passed. The first is an amendment to the lien law. It's Assembly Bill 2651, sponsored by Assemblymember Hinman. This bill would change notice requirements for self-storage tenants. While it was driven by some of the negative press stories that appeared recently in some of the online news, it would have lasting consequences because it would change the lien law forever. It would require 2 notices of sale rather than just one. And there would have to be a distance of I think a month between the 2 notices of sale. So it essentially doubles our timeline, and it also increases the minimum time for payment from 30 days to 60 days. So that ends up tripling actually the time period. We believe strongly that this bill would be an onerous burden on self-storage operators. We've lobbied with the Assembly sponsor. There is no corresponding bill in the Senate right now, and we've at least had productive dialogue with the sponsors. So we believe that we've got a lid on this one right now, but it's still active and it's still one to be concerned about. The next bill is also in the Assembly. It's Assembly Bill 662, sponsored by Assemblymember Rosenthal. This bill was introduced in early January. There's no companion bill for this bill in the Senate either. This was another one that was spurred by the Assembly members hearing our notice of negative press about auctions, and this bill would require self-storage operators to notify people not only in writing but by telephone of the notice of sale. It also doubles the minimum time for payment from 30 days to 60 days. From our perspective, the requirement for phone notice is completely unreasonable. It's untrackable and would be an onerous burden on self-storage operators. The fact is that I think many of us do make phone calls anyway, but having to prove that we made phone calls is a totally different story from having to prove that we sent something via certified mail. So we've lobbied hard against this. We've had productive dialogue with the Assembly sponsor. There's been no action so far on this bill since we had discussion with the Assembly sponsor. So as of right now, we believe we have a lid on this one as well. But again, this one is still active and could be moved at any time. The final bill I want to talk about is another lien law amendment. This is in the Senate. This bill is Senate Bill 9084. It's sponsored by Senator Sepulveda, and this bill actually originated back in November. It has no companion bill in the Assembly, and it actually has not even been reintroduced into the new session, though it is still active. This bill would prohibit any lien enforcement action during any state of emergency for New York State or in any individual county in New York State. So it would literally stop lien sales, auction sales now until the pandemic state of emergency is over. And going forward, if there were a local flood or a local storm or a local fire or something like that that would cause a county to declare a state of emergency, it would prevent lien sales during that time period as well. We believe that this is this bill, if the original bill that I talked about, the Senator Hoylman bill, passes, then there would be no need for this lien law amendment. And we believe that by accepting the terms of that original bill, that we can successfully get this one shelved and not have to worry about this bill either. The bottom line is we're fighting hard. A plethora of bills that are out there, some of which are only vague threats for the self-storage industry, others which are very, very direct and targeted at the self-storage industry. This is ultimately all fueled by not only the desire to protect consumers and small businesses during the pandemic, but also by negative stories that break in the press and individual constituent stories that lawmakers hear. I think it's unlikely that we're going to get through this pandemic without some sort of legislative action that is going to impact our business. But our intention is to keep that impact as minimal as possible. And if we can keep the legislative impact to be in line with the pandemic pledge, which many of us have already voluntarily signed up for, then I think that's probably the best result we can hope for. I'll just conclude with a couple of other comments. I think it's pretty clear that with all of these bills out there, lawmakers have a fairly low understanding of how our industry works. So we continue to try and educate, but it also indicates how easily influenced they are by one-off stories, one little story in the news or one little story from a constituent who is only telling their side of the story, does influence these lawmakers, and we have to be aware of that. That puts some really big responsibility on us. Number one, it really puts us into a position where we need to exercise extreme caution when we go through lien enforcement actions, particularly during a state of emergency like we're in now. We need to make sure that we have good independent legal advice when we take action, and we need to make sure we understand what's out there in terms of what laws have been passed and everything else. Second responsibility I think it puts on us is it puts a responsibility on us to do the right thing. As I said, the pandemic pledge, the voluntary industry pandemic pledge, was instrumental in opening the door for us to have some productive conversation with lawmakers. The more we show disregard for the plight of New Yorkers who are financially impacted by the pandemic, the more targeted we will be as an industry. And the more we show that we're actually good people and we're trying to do the right things, then the more freedom and the more leverage we have to be able to find an appropriate middle ground that we can live with. And third, I think we all have responsibility to get to know our representatives in the New York State Senate and Assembly. The more we have, an open dialogue with our representatives, the more we can educate them on how our business works and what elements of these bills that are out there are acceptable and which just are unworkable for us as owners and operators of our own businesses. I'll close just by saying it's really only because of all of you as members and supporters of the association that we can have the resources that we need to fight these battles. Chris Bombardier and Mercury are really important in our fight here. They're not cheap but they're really good and they're worth every penny. And I want to say thanks for all of you in supporting the association, allowing us to have the resources we need to continue to fight these battles. So with that, I'll turn it over to our chairman of NYSSA, James Coakley. Thanks, James.
Great. Good afternoon, everyone, once again, and welcome. I certainly appreciate the fact that so many of our members do recognize the importance and the benefits of these informational sessions that we've been putting on throughout the year. It looks like we're right at about 100 registrants logged in today. So, I mean, that's pretty substantial. So John, thank you certainly for providing that pretty detailed legislative overview and probably scaring the daylights out of most of us. But, it's important that we know what's out there. You've been a great advocate for our industry with New York lawmakers, and we certainly appreciate the vigilance that you and Chris have on behalf of all of us. So, before I kind of get into, my piece, I'm just going to try to share my screen real quick, folks. And I hope you can see it. I have just the headlines of a New York Times, LA Times article that was published just about a week or so ago. And, the caption is, "Who regulates storage companies during the pandemic?" And, it says, "No one, that's who." If that was the case, I think John's presentation, certainly would not have gone on to that extent. So it just reemphasizes to everyone that we are in fact out there. We are on the radar of lawmakers, and we do have individually all have a role to play. So ultimately, that is why we're here today, and it's to encourage our operators to certainly conduct their business in a way that's consistent, with Section 182 of the lien law. Conduct their business, to not jeopardize our position as an essential business in New York, and certainly to not bring any additional unwanted publicity, or certainly mitigate the risk of that as we can. Back in January at the NYSSA Economic Forum, we all learned that we're, for the most part, pretty fortunate to be in an industry and a business that is surviving this pandemic storm much better than a lot of other industries out there. And, we're here today to collectively try to keep it that way. That said, keep in mind that we're not here to instruct anybody how to run your business, nor are we, providing, legal advice. It's really here. Our intention today is to provide some practical guidance, and answer some questions that have been coming into the association, and just to try to navigate, smartly, these rather unique times. So the association and Eric and his staff have been fielding, various questions and concerns from members and operators and managers. And, the three primary, questions that seem to be coming up the past several weeks and months have been, how are you handling rate increases to existing customers now? Can you exercise the self-storage lien and sell the contents of the storage unit? And lastly, do you still need to follow COVID safety guidelines? So I'm going to try to take these in order and provide a little color on kind of where we're at with these and what some of the feedback I've been getting as I speak to other operators in the state. So back in March, when we were starting to see the first signs of the pandemic unfold and the state of the economy or state of emergency was put out there, vast majority of self-storage operators kind of voluntarily put the brakes on implementing existing customer increases, not really knowing where some of the laws and things might take us. And we all certainly recognize how important these increases are to our business, but in an abundance of caution, most operators, seem to put a pause, and rightfully so, I think. Towards the end of the summer and into August, we started to see things settle down a bit. Reopening plans from the state were rolled out. And, right around, August, September, we started seeing a number of operators reinstituting, their rate increase systems and processes. So I guess to answer the question, right now there is no legislation in New York that has been passed that prohibits self-storage operators specifically from raising existing customer rates. That's not to say that there won't be in the future, and of course that we are, John and the legislative watchdogs are watching that. There are, however, laws on the books about price gouging and other anti-consumer behaviors during a state of an emergency. And I think it's important that we kind of keep that in the back of our minds. I don't think that raising existing customers' increase, storage rent would necessarily constitute, price gouging, but there is, there can be negative connotations that come out from this, that can be picked up by, a news outlet or by a policymaker. So, I think we want to conduct ourselves in a business-like manner as we, if we do decide, if you as an operator do decide to start raising existing customers. There certainly was a temptation out there to try to make up for, 5 or 6 months of no increases to customers all at once. But from the experience I'm seeing within the industry, and not necessarily just in New York, that most operators, when they did start, their increases, they've done so, fairly conservatively, in the dollar amount, in the dollar amounts and percentages that they are, passing along to the customers. So, we are on the radar of the policymakers and news outlets, and that's why we're here to try to, continue to raise the awareness. We don't want to bring any of that negative publicity that could result in bills being passed, that could put a moratorium on increases during the pandemic, or even worse, some longer term, laws being codified that would survive the executive order. I think you as operators know your business and know your markets better than anyone, and you also know what your past practices have been. So I think if you're conducting yourselves in a manner that's been consistent with you have in the years, you're probably pretty safe on those fronts. I would say, if you are currently or planning to start raising existing customer rates, start conservatively, and more importantly, be flexible with customers who might call you upon receiving notice and ask for relief from that increase. Demonstrating your willingness to address the needs of someone with a legitimate hardship due to the pandemic will prove, I think, beneficial to you and to the industry in the long run. Whether it's an increase or any type of customer concern, I think it's important that they are addressed in a timely manner and a professional manner. So if you're be sure you have provided customers with a phone number or a link on your website or an email address that they can get in touch with a decision maker within your organization that can speak to a customer or work with a customer on a case-by-case basis. Obviously, I think most agreements have certain notice provisions, so we certainly want to make sure that you're also following your own rules that you've stated in your occupancy agreement. I think generally speaking, I've found that when a customer does raise concern, whether it's over an increase or another manner, if you can handle it professionally and quickly, usually you can come to a resolution that's pretty equitable for both parties. The second question that I raised, that has been raised pretty consistently, is can you exercise the self-storage lien and sell the contents of the storage unit? Before answering this as a yes or no, I'd also like to circle back to or encourage folks to visit the NYSSA website and look at the self-storage pandemic relief pledge that John had mentioned earlier. This is a pledge that we as an organization have endorsed. A countless number of our members have signed on and endorsed, as well as the CEOs of the 4 major REITs out there. As a side note, we did extend the pledge period out to May 1st, which has been pretty consistent with a lot of the other relief orders and things that are out there on the books. So we're trying to marry up with those as well. I think the existence and the inherent adherence to this pledge, as John mentioned, has not gone unnoticed by lawmakers, and it's really important. So to get back and answer the question, there is no existing laws on the books right now prohibiting a storage operator from exercising their lien rights under Section 182. So I would say that yes, you can conduct auctions or lien sales. There's no laws yet. I think that's really important to know. And John had mentioned that earlier. So we'd encourage everybody to read the pandemic. Certainly, if you haven't signed on, the pandemic pledge, if you haven't signed on, we'd encourage you to do so. But also to certainly check in with us at the association, either through our website, phone calls, whatever, to try to stay up to date as best as possible. And always certainly don't ever, not feel comfortable reaching out to your own attorney or one of the attorneys that provide assistance to the association. Mark Kunkin and Joe Miller and Pat Quigley, they've volunteered themselves, time and time again, and have always been, given good insight to members. So, keeping with the pledge, we really need as operators to be diligent in the processing of our lien sales. If a customer in the lien sale process does alert you that they're experiencing economic hardship due to the pandemic, please, we encourage you to be flexible. Take steps above and beyond, what's required in 182, whether it's a little extra time or a little extra effort in phone calls or emails or whatever it might be. Your willingness to work case by case with the customer, could be just enough to help us all fend off, some unwanted legislation. As the pandemic pledge calls out, we've offered a couple of fairly common alternatives to working with a customer who's approached us over a hardship, and whether it's a temporary rent deferral, payment plans, or abating or writing off rent in exchange for the customer to vacate the unit. I mean, these are all, I think, fairly plausible and reasonable, and can be managed without a whole lot of undue hardship to the operator. So whatever you do, I think it's important that you document the steps you're taking, and that you have a clear understanding of what the deliverables are both for you and for the customer. And if it's a written payment plan, or a notice to abandon property or something like that, it behooves you to have that in place to protect your interests. Ultimately the purpose of a lien sale is to collect, or to try to collect rent that was owed to us, or to return the unit to the inventory. And while some of these alternatives might delay the ultimate outcome, in the long run, I think it's going to be better for you that you have a mutually agreed upon resolution with the customer, should it even eventually end up going to lien sale. So simple answer is yes, you can conduct them, do so very carefully, participate in our pandemic relief pledge program, and continue to check back for guidance. And obviously if we're alerted of something, we'll certainly make sure that we can do an email blast, or we'll post those news updates to our members. And lastly, the third question, I think, is a little more straightforward, has been, do we still need to follow COVID safety guidelines? I think simple answer is yes. They're still in a state of emergency. The guidelines that the state and requirements that the state has put out, they may vary based on your operation. If it, smaller sales office with, primarily exterior access units, what you may have to do certainly may be a little different than, somebody in a multi-story building with interior loading and elevators and such. But, things like wearing a mask, keeping a daily log or questionnaire for employees to complete, when they complete each morning when they come in, sanitizing high touch point areas, and maintaining maintaining safe distances, all make pretty good business sense these days for you, for your employees, and for your customers. So I encourage you to visit the state's website. It's forward.ny.gov, and if you look there, they've actually provided several pretty good PDF templates that you can download and keep on hand, and follow some of the recommended guidelines. And what we've kind of found as an operator, having a plan in place and demonstrating that you're following it, if and when the health department does show up and inspect you, there really shouldn't be any real cause for alarm. We've had multiple site visits from health inspectors, and really have not had much of an issue at all. I mean, they were actually had looked at some of the logs and so forth that we were keeping, and we're pretty happy with what we were doing. And again, I mean, I think these are procedures that they just make good business sense. If we're demonstrating that we're making the good faith efforts to keep our employees and our customers safe, I think that's really the spirit behind these guidelines and such. So I apologize if I moved through some of the things quickly, but I did want to get some of these really critical items out there, and really stress to our members and folks who've come in to view the webinar, that we do need to carry out our businesses, but we want to be cautious, and we want to conduct ourselves in a business-like manner, and be willing to accept or work with customers, on a case-by-case basis should they approach us. Eric, if you'd like, I can flip it back to you if we have any questions from any members.
Sure, I do have a couple of questions. I'll direct the first one to John. John, when do you expect a decision to be made on the Self-Storage Pandemic Act?
The legislature is meeting infrequently, but they are in the middle of budget conversations now, and assuming they fit this in the middle of some of their budget discussions, it It could be within a couple of weeks, assuming we get the language changes that we want. That will require at least a few days, and the bill would have to be duplicated on the assembly side, and that would have to be reintroduced formally with the new language on the assembly side. So we're at least a couple of weeks away from that, but I assume that there would be little opposition to it, and on both sides it would sail through committee, and the language in the bill has it being implemented or being effective immediately. So add a week for the governor to sign it, and we're probably within 3-ish weeks, give or take.
Okay, great, thank you. And for Peter or James, what sort of proof would a tenant need to present if their payments were interrupted due to COVID-19?
Sorry, I was trying to get off of mute there. Sorry, guys. That's a great question. I don't. Simple answers. I'm not 100% sure, and we'll try to clarify that for everybody. But I think what I've done, and John, I know you may have some more color on that, and I'll kind of turn it to you then, and then I'll kind of circle back with some of the practices we've kind of been going through.
Sure, I think I'm probably going to say exactly what you're going to say, James. But it's likely if the language is similar to what's in the other bills that are protecting small businesses and residential tenants, there will not be a requirement for specific proof, but instead the tenant will have to sign a declaration under penalty of law that they are telling the truth, and that's about the extent of it, at least from a codified standpoint. Yeah,
I appreciate that, and I think that is the case. I mean, we really haven't pushed back too hard on anybody who has approached us. Most of the folks that we found that truly are going through it are actually the ones that are returning phone calls and emails in our collection process. So typically, we probably work with those customers anyway, even if it wasn't, even if we weren't in a pandemic period. I mean, if somebody will, get back in touch with us, we'll usually try to work out some type of alternative.
I'll add that California, or at least parts of California, already have a requirement very similar in place, where self-storage operators must give tenants the chance to do a hardship declaration, and tenants must make an unverified, unprovable claim in writing of their hardship. And the reports from California and from the Self Storage Association are that a very small percentage of tenants who are in default are actually exercising that right. So we feel reasonably comfortable that James, the point you made is dead on about communication. The people who truly have a hardship will communicate with us, and that'll be a small percentage.
Excellent. Thank you very much. Well, we've
John,
reached.
I'd just like to weigh in on this. It's important that we have our managers or the people at the front desk approach this with not with their emotions, but with their brain. When they're dealing with customers, we all have customers that some of our customers might take advantage of the situation, okay, who are not really affected by this pandemic. So we're urging everyone who's dealing with this situation to keep a detailed record of either your phone conversations or emails or letters or whatever you need to do. Keep a file on whatever you're discussing with that customer to see how we could move this along so that there isn't an issue later on.
Excellent. Thank you very much, Peter. And thank you, gentlemen. Appreciate your time and your comprehensive update today. A recording of this session will be posted on our website next week. We appreciate everyone joining us today. If you have further questions, we encourage you to email the association at admin@nyselfstorage.org or call us at 518-431-1106. Thank you again and have a great week.
Great. Thank you, Eric. Thank you, guys.